Go.
Hello, my name is Jay Chauhan. I am a lawyer in Richmond Hill, and I lead a group called Angel Mentorship Group, in which we provide instructions and support to a number of lawyers and paralegals. And today's topic on the 28th of June 2020 is on the sale of assets. I want to describe to the group and anybody listening is how does the sale of assets take place in a practice which is called commercial law practice. So just let me go back and not just talk in the normal way that the subject is taught in the schools and in the bar admission course, but rather from the point of view of the practice. So a lot of my discussions in the mentorship group are based on the practice issues, because what happens in the teaching system in the common law jurisdictions, including Canada, England. England is where the common law was invented, but what happens is the learning process, the subject is taught in terms of categories of the law. For example, the sale of assets, you would learn the Bulk Sales Act. But I think knowing the act alone is not sufficient. If you see in the bar admission notes, actually there'll be more notes of what you would do in the conveyancing process in the sale of assets. But nobody will describe to you actually what typically happens in the lawyer's office when you're carrying out the actual transaction. So that's what I'm going to do, to try to explain in practical terms what happens in the sale of assets transaction. So the first issue is that the agreement comes to you in the sale of assets from usually an agent, because the agent of real estate, agent person who normally deals with the real property, the commercial or residential, have their knowledge base and the forms that they typically use, which they are also trying to use in the sale of assets. So they do have standardized forms, but most of this time that you see a particular form, it will not be adequate from the lawyer's point of view, either if you are a purchaser in particular, but even if you're a seller, it is important that you review the agreement, but sometimes your hands are bound by the fact that the agreement was signed, and the agents do not necessarily want the lawyer to get involved in the process of negotiating the transaction itself, because they feel that each lawyer protecting their own client is basically trying to protect the client, making the transaction more difficult to complete. And the interest that the agent has is to try to complete the transaction and then give it to the lawyer for the completion of the so-called paperwork. But that creates a lot of problems. So I won't go through all the problems, but this practical measure of having the agent prepare the agreement is not adequate from the lawyer's point of view. That's the main point that I want to make. So what can you do if the agreement is not fully done, or the client has first mentioned to you? You can tell the client that they can first show the agreement after the agent has negotiated the terms of the sale, the down payment, etc., that the lawyer should look at it. And there are many considerations that the lawyer has to look at, including the tax aspect of the transaction. So those things will not usually be addressed by the agent. And I won't be in the short video, it will not be possible for me to go through all the issues, but there are tax implications of the transaction. For example, recapture. I think that is one of the problems. Another question is that if you have to structure the transaction from the point of view of the tax, then there are two basic ways in which you can sell the business. One is the sale of shares, which is the sale that you do when you have a corporation and you transfer the shares between the vendor and the purchaser, and the corporation owns the assets. And when you control the shares and they are transferred to the buyer, then through the ownership of the company, you control the ownership of the assets, is one way of completing the transaction. So you can do it by the purchase of shares or purchase of assets, and there are tax implications and many different issues that arise. But one of the key issues that you have to think about is the liability. So from the liability point of view, if you take over a corporation, all the assets and the liabilities continue to remain the assets and the liabilities of the purchaser, and therefore responsible for any debts of the company. So very often the lawyers will prefer a sale of assets than the shares. But in some situations, what you can do is you can do even a simultaneous transaction that you will transfer the shares and the assets to the purchaser, and then you can have your own company that actually takes over the shell of the company after the assets are sold. But it's rather complicated to explain in a short video, but you can have the benefit of both the methods if your client is willing to understand that the reasons why you would prefer the asset purchase rather than a share purchase, but it is still possible to take over the shell of the company, meaning the corporate entity, and still have it in your hands for whatever purpose you want to do. There are many other issues, for example, the trademarks and other things in the name of the company that may be relevant if you take over the shares of the company. So I think that's the broader context, which is not usually taught in the school or in the bar admission notes, of what happens in a practical sense with the agent and the decisions you have to make, how to evaluate between the shares purchase and the asset purchase. Once the agreement is in place, the lawyer of the buyer will then do the title searches, and the title searches in the case of the asset purchase is not straightforward like real estate transactions. So there are about 5, 10, 15 different things that you can look at in the transactions to search, like a PPSA, Personal Property Security Act registrations. You can look at the Bankruptcy Act. You can look at the judgments, executions, and a number of other issues that you can look at. So it's a question of evaluation. It is in my practice to try to show to the client what things can be searched and what are the decisions of the client that you can document. Because the lawyer's role is to try to provide a good title based on the opinion he provides and based on the decisions the client is making. So if you want to practice and have a client not point fingers by negligence in the future, then you have to be very careful in terms of what searches you do, have them documented, have them approved by the client, and then in your reporting letter you can mention as to what the client wanted you to do, and that is what you did. So in my practice of 48 years in Ontario, in Canada, I didn't have any negligence issues because of this precaution that I've taken, that you look at the transaction not only from the point of view of carrying out the transaction in mechanical fashion by giving the title to your client, but rather from the point of view of what the negligence might be in the issues that are usually peripheral to the transaction, such as the tax, liability, undisclosed statements of the financial statement, and these kind of issues create problems after the closing. So the retainer that you have in the reporting letter you create are fundamentally important. The rest of it you learn the bar admission courses of how to carry out the transaction, which I won't deal with in this case. But I would like to do a separate lecture on this issue as well for our group and any other person that would be interested. And the reason for that is that many lawyers who do not get the full training in the bar admission notes or even in the university, they end up practicing family law, criminal law, and real estate, and there are typical areas of law. But if you get to know how to do corporate commercial law, there is much more potential for you to make better income. And then we are in this jurisdiction, in most common law jurisdictions, in a private enterprise competition model of the delivery of the legal service, which means that if you know the areas of law which are more lucrative, then you can make better income. So it's very important for me in our group to try to show these areas of law to you so that you can practice that area of law. So I hope that was helpful. And if any questions or you'd like to work with us in the Angel Mentorship Group, please join the Facebook at the page Angel Mentorship Group. And anybody would like to work with us closely in real transactions, they're also welcome to do so. If you're a lawyer and want to learn a new area of law in a specialty, then you're also welcome to connect with us. we'd be happy to work with you. Thank you.